We are a nonprofit law and policy center. We're based in Milwaukee, Wisconsin. A lot of our work is related to limited government, speech, transparency, education reform, which is what we'll be talking about today. So we're really glad to be able to provide this as a resource for you. Before we even get started with the substance for today's presentation, I want to mention just a few things. So this will be recorded. So if you want more detail, if you want to go back and watch it later, this will be recorded and shared later on. And for anyone who signed up, you'll get a link as soon as it's posted. And the other thing I want to mention is please do use the Q&A function throughout the presentation. Robert and I both will be taking questions at the end of the presentation, so feel free to put your questions in there and we'll get to as many as we can. And the other thing I want to mention is that a lot of the content for our presentation today is also in a report. So if you ever want to refer back to this, if you want the citations, if you want more details, this is publicly available online. Robert and I co-authored this with Riley Fletcher, and we hope that it is a way for school board members, but also beyond, and folks who are non-lawyers can understand some of these really significant, famous First Amendment cases and implement them in a K-12 setting. So I am going to introduce Robert, and he's here as an expert. He's going to help us bridge the gap between law and practical implementation. I'm excited to introduce Robert Pondiscio. He's a senior fellow at the American Enterprise Institute, or AEI, where he focuses on K-12 education, curriculum, teaching, school choice, and charter schooling. His full bio is online. I'd encourage you all to check it out. Also follow him on Twitter, rpondiscio on Twitter or X. As a former educator, as a policy expert, he has a wealth of experience and insights to share about how school board members can put these principles into practice. So I encourage you to take advantage of having him here with us today. And I'm going to turn it over to Robert.
Thanks, Corey, and thanks to your colleagues at Will. I should also note about that paper that Corey and I wrote with Riley Fletcher. That is intended to be the first of an ongoing series of papers about the intersection between law and education practice of particular use to school boards or school board members. So stay tuned for future papers in that series. So I'd like to talk about one of the most important and increasingly controversial, let's be honest, aspects of the school board member's job, which is choosing school curriculum and setting policy governing teacher speech. Let's be blunt. Public education has become intensely politicized. You know this. Many of the topics that were once considered settled are now fiercely battled in public fora like school board meetings. The role of race and history in the classroom, gender identity and sexuality, even the very nature of what it means to be an American. I say that as a former high school civics teacher. Some of these so-called culture war issues might be what motivated you to run for school board in the first place. Look, whenever anybody laments so-called culture war problems in school or claims that they are a distraction to the business of teaching and learning, I can't help but remind them of what we do in schools. We literally decide on behalf of other people's children the books they should read, who are our heroes and villains, what are the behaviors, attitudes, beliefs, and values that we praise, what are those that we condemn. In other words, a school is literally an institution built to transmit culture and values to children. It's just crazy to think we can avoid these issues. Someone has to make those decisions, and it's you, the school board. So it's easy in this environment to feel besieged, right? School boards are increasingly finding themselves on the front lines of these battles. They face pressure from parents, from activists, even the media. It's tempting in this environment to defer to the so-called experts, to the professional staff of schools. And again, I'm speaking as a former teacher, to lawyers, to consultants. After all, you might think, hey, they're the ones who went to school for this. They're the experts. I'm not. I'm a civilian. But let's be clear. You are the expert as a school board member. You are the person or persons elected by your community to represent their values and interests. Most importantly, you are the ones with the legal authority to set the course for your schools. So the law is clear on this point, and Corey will go into much greater detail shortly. School boards have the ultimate authority to establish school curriculum. Teachers are required to follow that curriculum as well as all the school board policies and applicable state laws. Teachers in K-12 education do not enjoy the same level of academic freedom typically granted to teachers or professors in higher ed. And that's not a matter of opinion, it's a matter of well-settled legal precedent. As the Seventh Circuit Court of Appeals put it, children ought not to be subject to teachers' idiosyncratic perspectives. Now, let's be clear, this does not mean that the relationship between a school board and district staff should be adversarial. Collaboration and mutual respect are essential for any successful organization, but it does mean that the relationship should be independent. The school board is not there to, quote, support the district. It's there to exercise oversight. So you are the trustees of the public's interest, and that means asking tough questions. It means demanding accountability, and when necessary, it might mean pushing back against the recommendations of professional staff. Let's not overstate the concern, however, and assume that every teacher is determined to use his or her class to indulge their personal or political views. I think too much has been made of that. But by the same token, it's the rare teacher who sees themselves as a state actor or a government authority with influence over a captive audience of other people's children. See, if we did see ourselves that way as teachers, it would imply an extraordinary degree of humility on the part of teachers. So the mismatch between the reality of teachers as public employees legally bound to deliver an approved curriculum and the signals that we get in our teacher training about our roles, that's the heart of growing tension over teacher speech. Many teachers enter the classroom after being encouraged in their training and their professional development to view their roles as an explicit form of social activism, even to be anti-racist educators dismantling systems of oppression. This is especially true when it comes to issues of teacher speech. Let's be honest, some teachers do see their classrooms as platforms for personal activism. They think they have a right, even a duty to, quote, speak truth to power or to challenge the status quo. Behind me on my shelf, I could show you my master's portfolio that I compiled when I was in teacher training that encouraged me to think of my role as exactly that. Teachers are often encouraged in this belief by schools of education and teacher preparation programs. Not all of them, but not none of them either. But again, the law is clear, and we should be clear on this. Teachers are not free agents. When they are in the classroom, they are speaking on behalf of the school district. Their speech is considered, quote, hired speech, and it's subject to the same limitations as any other government employee. This has been affirmed by numerous court decisions that Corey will discuss shortly, including the landmark cases of Garcetti versus Ceballos and Mayer versus Monroe County, that again, Corey will discuss in detail. Now, look, I know what some of you are probably thinking. Hey, what about academic freedom? Don't teachers have a right to express their own ideas? Well, obviously, teachers have First Amendment rights. They can speak their minds on matters of public concern outside of the classroom, and they should. But when they're acting in their official capacity as teachers, their teacher speech is subject to the legitimate oversight of a school board. This is not censorship, it's common sense. Public schools are not soapboxes for teachers to promote their personal views. They're places where children are supposed to learn a common body of knowledge and develop skills, free to the degree humanly possible from indoctrination or political bias. I'd also like to say a few words about expertise and encourage you not to be intimidated by school or district staff who will insist that they are the experts in education and therefore are due your deference. We've seen the consequences of blindly accepting so-called best practices. If you've listened to Emily Hanford's work, her landmark Sold a Story podcast, and other similar reports, for decades, flawed reports or flawed approaches to reading instruction were embraced by the educational establishment. This led to generations of children struggling to learn to read. We're struggling with this to this day. So we have to learn from those mistakes and be willing to question expertise, particularly when it conflicts with common sense and the best interests of our students. Look, the past few years have been tumultuous for public education. We've seen a decline in public trust fueled by pandemic disruptions, controversial curriculum choices, and a sense that schools are sometimes prioritizing activism over academics. This loss of trust is deeply concerning, but I don't think it's irreparable. As school board members, you have a crucial role to play in restoring faith in public schools. So I would encourage you to recognize that public schools are not platforms for personal agendas or for unrestrained personal expression. They're professional spaces where teaching and learning should align with broader educational goals and community expectations. That means setting clear, transparent curriculum guidelines and ensuring the teacher's speech stays within the four walls of those boundaries. Remember, too, teachers are considered hired speech in the classroom. And while they absolutely have free speech rights as private citizens, their speech is not protected when speaking in their official capacity as teachers, as educators. And open communications with parents is also critical. We have to be transparent about curriculum content and policies, provide opportunities for parents to review materials, attend meetings, voice their concerns. By fostering respectful dialogue and actively listening to community members, I think we can bridge divides and find common ground. So before I turn it over to Corey, I'm just asking you to embrace your role as school board members. Don't be afraid to ask tough questions. Don't be intimidated by so-called experts. And above all, don't abdicate your responsibility to set your course or set the course for your schools. So I look forward to answering questions shortly, but for now, I'm going to turn it over to Corey Brewer for more.
All right, thank you very much. I want to provide an overview here before I get into some of these very significant First Amendment decisions by the United States Supreme Court. First of all, this is not legal advice. It should not be considered legal advice. Similarly, it is not going to be a deep dive legal analysis into these cases. The goal here is to empower you. I want to make you aware as school board members, school district administrators, if we have any parents, grandparents on this call, I want to make you aware of some of the law that's out there so that as these issues arise in your local communities, you might say, oh, I think I remember hearing about that case, or oh, isn't there a decision that's relevant to this? And just be able to ask these questions as you advocate for the children in your local communities. So this is intended to provide that foundation and equip you to be able, as specifically school board members, to do your job to the best of your abilities. And like Robert said, thank you. Thank you. We know that this is not an easy job, and you have sincerely the best interest of the children in mind. So hopefully you find this information helpful. And here is where we will begin. What is the text of the First Amendment? I was going through this presentation, I'm summarizing several cases, and I thought, well, you know what? We should probably start with what the First Amendment actually says. And if you've been to any of our in-person presentations before, you might have one of these handy dandy little pocket constitutions. I know it says Wisconsin Constitution, but this is actually the United States Constitution, QR code to Wisconsin here for folks that are local. But we have these available for you all as well. So let's start with the First Amendment. Congress shall make no law respecting an establishment of religion or prohibiting the free speech the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. So this is our starting point for all of this case law that our United States Supreme Court went on to analyze. And before I get into this first case, this one I think is probably most relevant to curriculum decisions that you have as a school board. And on that point, Robert discussed authority. I want to just encourage you, whatever state you're in, most states, probably every state, but take a look for yourselves, have a state law that lays out exactly where that authority is, where it comes from, that you as the local elected officials, you as the school board, have the authority to set the curriculum, oversee the district. It'll include language along those lines. So please do take a look, ask your legal counsel, and you'll be able to point to exactly where that is in your state law. Now, moving to the First Amendment, this is true for obviously any state. This first case that's very famous, Garcetti, this isn't an education case. We're starting with a case that's not even about education, but it applies to education. It's noteworthy for its refinement of public employees' free speech rights, and public school teachers are obviously public employees. So here, this case involved an LA County Deputy District Attorney, Richard Ceballos, who wrote a memorandum in which he recommended dismissing a case on purported misconduct by the government. I think it related to a search warrant affidavit. He criticized the handling of the case. And after being subpoenaed to testify by the defense counsel, the district attorney's office essentially took retribution. Richard claimed that he was reassigned to a lower position for criticizing this, transferred to another location, and denied a promotion as a result of his speech. That was his argument. But we're going to fast forward through a lot of these to provide an overview. When this got to the United States Supreme Court in a 5-4 decision authored by Justice Anthony Kennedy, the court held that his employers were justified in taking action against him because, and this is important, he spoke out within his authority as a public official. They noted that speech by a public official is protected only when it is engaged in as a private citizen. So here you have this deputy district attorney. He's cooperating with the defense as a public official. He spoke in his capacity as a deputy district attorney, and his employer was therefore authorized to restrict his speech. So this one was one where it actually put a limit on free speech, and the court kind of laid out exactly why that is. So the First Amendment, kind of a takeaway here, it protects the right of a public employee to speak as a citizen addressing matters of public concern. But when public employees speak in the course of their official duties, think here teachers in the classroom providing instruction, kind of like how this district attorney did when he testified, that speech is functionally considered government speech, and therefore it may be regulated. All right, moving on here to another very famous case, Pickering versus Board of Education. This is a landmark case. It set a high standard for firing teachers because of their speech. Here we're going all the way back to 1968, and it's named after the Illinois teacher Marvin Pickering, who wrote a letter to the editor. It was published in the local paper. He complained about a defeated school board proposal to increase taxes. His letter kind of noted and criticized how the board handled past proposals, criticized allocation of funds, and he was actually terminated on the grounds that his letter made erroneous public statements and complaints about how the board handled past funding proposals. The board felt that his letter was, quote, detrimental to the efficient operation and administration of the schools, end quote. He filed a lawsuit. He argued his speech was protected under the First Amendment. And the Supreme Court here agreed in an 8-1 decision. They reversed the decision of the district court and held that the First Amendment did protect his speech in this instance. School board members, be mindful of what has come to be known as the Pickering balancing test. So if you ever hear the Pickering balancing test, it's referring to the decision in this case. There is a part from the majority opinion by Justice Thurgood Marshall. He said, the problem in any case is to arrive at a balance between the interests of the teacher as a citizen in commenting upon matters of public concern and the interests of the state or the government as an employer in promoting the efficiency of the public services it performs through its employees. So this case provides guidelines to interpret when constitutional protections must be accorded to public employee speech. And just a few specific things I want to note here. First, determine whether the employee spoke as a citizen on a matter of public concern. If the answer is no, like in Garcetti, he was in his official capacity, then the possibility of a First Amendment claim arises. The question becomes whether the government employer had an adequate justification for treating the employee differently from any other member of the general public. So despite these alleged erroneous claims in Pickering's letter to the editor, the court explained that teachers are, quote, some of these quotes are very famous. If there are any attorneys on this call, I'm sure you've heard these, but they explain that teachers are members of a community most likely to have informed and definite opinions regarding school-related issues. So, quote, it is essential that they be able to speak out freely on such questions without fear of retaliatory dismissal, end quote. So similar speech is not protected if it contains false statements knowingly or recklessly made. But here it couldn't be proved that he made his erroneous statements knowingly, and his speech was protected. Takeaway, school board members. Keep in mind that teachers can't be compelled to relinquish their First Amendment rights that they would otherwise enjoy as citizens to comment on matters of public interest. And as you're crafting employee speech policies, I know there are several model policies out there. Your district probably has one of these in place. Just really consider that speech by teachers can be really important to public debate because teachers know things about education and they're important to inform public discussion, right? So include as much detail as possible so that the administration, the school board, and the staff know what their rights are, where the line will be drawn. For example, threats about colleagues, knowingly false statements, confidential information, or statements that disrupt the workplace. These are types of things where it might cross the line. But try to have a policy in place that is as clear as possible, just so that everybody involved knows where that line is and what adverse action could be taken against employees. To close this one out, I'll just mention that we at Will have a model policy on this topic. We've litigated cases on this topic, so we tried to write this policy in as clear of a way as possible for everyone involved, and it includes some legal analysis at the end as well. That is free and publicly available on our website as well. All right, I am going to move on here to school prayer. And really the big case that I want to talk about is Kennedy versus Bremerton School District. This is a pretty recent case. I'll give a little bit of the background before I get into what this means for schools, but Joseph Kennedy was a high school football coach in Bremerton County, Washington from about 2008 to 2015. It was his practice to routinely engage in prayers. Often his players would join him during games, after games, and the school district. They never really weighed in on this habit for quite a long time, but they finally took issue with it in September of 2015, and they asked that he discontinue this practice of praying to protect the school from a lawsuit. They were concerned about, I think, primarily an Establishment Clause lawsuit. So, under the Establishment Clause of the First Amendment, government entities, including public school districts, are prohibited from the establishment of a religion. Go back to that text of the First Amendment. And in Kennedy, the school district took the position that his prayers amounted to, quote, problematic practices in violation of the Establishment Clause. But Coach Kennedy refused to stop praying after games, and he was subsequently fired. He sued the school district for violating his First Amendment rights. Now, again, fast forwarding to this case getting to the United States Supreme Court, this was a 6-3 decision. The court ruled in favor of Coach Kennedy. They cited the free speech and free exercise clauses of the First Amendment and held that individuals engaging in personal religious observance cannot be prosecuted by the government. In this case, the court gave a definitive answer to the question of whether a public school employee's prayer during school sports was protected speech and whether the public school employer could prohibit praying to avoid violating the Establishment Clause. Quote, Respect for religious expression is indispensable to life in a free and diverse republic. That is by Justice Neil Gorsuch in the majority opinion. He said the Constitution neither mandates nor tolerates the government to suppress such expression. So, like some of the cases that we've already gone over, it's important to recognize that whether the speech in question occurred within the speaker's professional capacity, here was Coach Kennedy leading his prayers as a coach employed by the public school district, or was he praying as a private citizen? Some of the things the court noted in this case, and I think this is important because as all of you navigate these, just know that the facts of every case matter a lot. But the court noted he never pressured or encouraged any student to join in his prayer. Students were never required to join, and the court concluded that his prayers were not within the scope of his duties as a public employee. His prayers were private speech, and the district was not justified in restricting them. So now you as school boards, how might this impact you? It could apply to teachers saying grace quietly before lunch, wearing a cross necklace to school, praying before or after extracurricular activities. I just want you to be aware of this and know that permitting private speech, including prayer, is not the same thing as forcing students to participate in it. That can be constitutionally problematic. This is not directly related to prayer, but it's a related issue I want to touch on. And it's a question that we get quite a bit here at Will. Can districts prohibit staff from displaying political or controversial signs and decorations? Yes, the answer is yes, but any policy prohibiting teacher expression regarding political and controversial displays in the classroom must be viewpoint neutral. You can't attack one viewpoint and allow the other, or vice versa. You can prohibit these, but it has to be done in a right way. So you can't favor a particular belief, a particular political system. That's kind of the general overview to be aware of. Examples, and we've heard this, school board members, parents, community members, they might view certain signs to be an unnecessary distraction, an attempt to indoctrinate students. They want the focus to be back on learning to read and write and learning how to do math. But if school boards want to prohibit these, quote, controversial political displays, they should consider adopting a policy that balances, again, here we are back to this balancing test, balance the teacher's rights as a citizen and commenting on matters of public concern with promoting the efficiency of the public services it performs through its employees. We also worked on a model policy on this topic here at Will. So if you want a starting point, if you want a model policy for how to implement something like this, we have a template for you. And the takeaway here, when public employees make statements within the scope of their employment, they are not speaking as citizens for First Amendment purposes, and the Constitution does not insulate their communications from employer discipline. Importantly, when it comes to school personnel and freedom of religion, teachers may take part in prayer during the workday if it does not disrupt the educational environment or interfere with their professional duties, and they may wear religious attire or symbols consistent with their faith. But when they speak in their official capacities, they cannot engage in prayer, require students to join, and staff cannot initiate or participate in student prayer during instructional time. So those are some of the big points we want you to be aware of. And the next thing I'm going to turn to, we got a lot more cases here to get to, is student speech. So before I do that, I'm going to talk about student prayer. Like student free speech rights generally, students enjoy stronger rights than teachers do to freely exercise their religion. For example, students may engage in personal and voluntary prayer and may not be discriminated against based on their religious beliefs or expression. School officials may not impose rules on religious student speech and activities if they are discriminatory based on religion. Similarly, students may discuss religion and pray with fellow students during the school day on the same terms and conditions that they can engage in any other conversations unrelated to school curriculum. Students may express their beliefs about religion in their schoolwork, and such work must not be evaluated by regular academic standards and without religious, it must be evaluated by regular standards and without religious discrimination. Student clubs and organizations related to religion must be permitted as well, subject to the same guidelines as non-religious clubs. We also have a policy on prayer in schools, so I'll just try to flag these for you as I go in case anyone's interested in these model policies. All right, I'm moving on here to student speech. So here's where we get to the kind of the overarching view. Yes, students have stronger First Amendment protections in school than teachers do. And the first case I want to discuss here, you've probably heard of the name Tinker, or maybe you've heard of the facts of this case, but you don't know all the details. This is kind of the first case to be aware of regarding, the first big case to be aware of regarding student speech. So here, this occurred in 1965. A group of junior high students in Des Moines, Iowa, planned to protest the Vietnam War by wearing black armbands to school. So that was their plan. And plans of this protest leaked. And when that happened, the school officials kind of hurried up and they created their own plan to suspend any of the students wearing these armbands. The school didn't prohibit the wearing, so just generally, the school didn't prohibit the wearing of all symbols of political and controversial significance. However, in this instance, they decided that black armbands worn to exhibit opposition to the Vietnam War were going to be singled out. And the students who did wear them, they were suspended, and they filed a lawsuit contending that their suspensions violated their First Amendment right to free expression. This, like I said, it's a very famous case involving education policy and practice. The Supreme Court decided in a 7-2 decision that students do not, quote, shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. Public schools can't prevent students from expressing particular ideas simply because their message might contradict the school's preferred message. So just going back to that schoolhouse gate quote, again, very famous. You probably have heard this or you will hear it. I will mention, though, that dissenting opinions on the case, so the two that were not with the majority in this case, stated that wearing the armbands interfered with the school's operation. So that was kind of what the other side was trying to argue. However, a distinction was made between merely wearing the armbands and the conduct of those wearing the armbands. Schools may suspend students for actions taken in protest, but not just for wearing something symbolizing protest. The armbands represented pure speech, which is protected. Takeaway here, fear of misconduct essentially drove the school's action rather than any actual misconduct. Tinker's revered by many as the court's most consequential student rights case in the court's entire history, really. It vindicated students' right to express their views in school, to regulate and punish student speech. I'm sorry, I'll say that a little bit more clearly. In order to regulate and punish student speech, because obviously this is not an unlimited right. If a district wants to regulate or punish student speech, districts basically need to show that speech in question materially disrupts classwork, involves a substantial disorder, or somehow invades others' rights. And that's what the cases that I'm going to talk about next discuss. What happened after Tinker? How was Tinker applied, and where are these limits? So the next case here, Bethel versus Frazier. Bethel arose from a vulgar speech that a student gave to his fellow high school classmates at a school assembly. He included a lot of innuendos, and the school found it to be very inappropriate. Individuals thought he included a graphic sexual metaphor, and in turn, the high school suspended him for use of obscene language. Here, the court held that the First Amendment doesn't prevent the school district from disciplining a student for giving an obscene speech at a school assembly, and that it was appropriate for the school to prohibit the use of vulgar and obscene offensive language. Chief Justice Warren Berger pointed out that the vulgar speech in this case in Bethel is distinct from the controversial political expression in Tinker. While students are protected to voice their political opinions in a school setting, schools have the right to prohibit profanity and speech with inappropriate sexual conduct or content. So in this case, the student's speech fell under what the high school deemed as language, quote, substantially interfering with the educational process. Here we have another case that applied Tinker. Hazelwood School District versus Kuhlmeyer. In this case, the court considered whether it was appropriate for a principal to delete 2 articles from the school-sponsored, student-led newspaper. He found these articles to be inappropriate. Specifically, the principal received the proofs of the articles, and he ordered that a few, I think 2 pages, be withheld from publication. The students claimed that doing so was essentially censorship and violated their rights under the First Amendment. The court, in looking at this, answered no. The First Amendment doesn't prohibit schools from censoring student speech in a school-sponsored publication. Schools can set high standards for student speech that they disseminate, and schools can refuse to sponsor speech that is, quote, inconsistent with the shared values of a civilized social order. So just to wrap this case up, it's similar to Bethel in kind of the reasoning. This case, the court made clear that the type of student speech that schools can censor, it specifically addresses concerns over content published in the school's name. Even when composed by student journalists, the school, as the provider of funding and dissemination, doesn't impinge on the journalist's First Amendment rights by removing content from its own newspaper. I have 2 more cases for you all today that we will get through before we turn to Q&A. So just a reminder to put any of your questions in the Q&A function. Next case, Morse versus Frederick. This is often referred to as the Bong Hits for Jesus case. You'll see in the picture on the side here, it says free speech for students. But what this involved was a student who held up a banner, very large banner, that said Bong Hits for Jesus. And the Supreme Court in this case found, citing Tinker again, that the First Amendment does allow schools to prohibit students from displaying messages promoting the use of illegal drugs at school supervised events. In this case, the principal took away the banner, suspended the student, and then the student filed a lawsuit alleging a violation of his First Amendment right to freedom of speech. And the court said, yeah, this is actually consistent with the principles in Tinker. A school district can restrict student speech at a school event when that speech is reasonably viewed as promoting illegal drug use. So one more about kind of the application of Tinker. This is a recent case. In this case, a student tried out and failed to make her varsity cheerleading team. She posted on Snapchat with a caption that used vulgar language, criticized various school programs. She was subsequently suspended from the junior varsity team for violating team and school rules. And if you are following a theme here, she sued the school and she alleged her First Amendment rights were violated. The school district asked the Supreme Court to decide here whether Tinker applies to student speech that occurs off campus, right? Because we're talking about Snapchat here, social media. The court cited 3 factors for consideration, and I'll this is not verbatim from the court's opinion, but I'll go over what those 3 factors were. First, Schools are rarely seen as acting in place of parents regarding what students do off campus. Second, if schools were to try and control what students say outside of school, they would essentially be controlling what they say at all times, not just during school hours. And for this reason, courts should be skeptical of schools' efforts to do this. And third, schools should protect students' rights to say things that others might not like, especially when they say these things outside of school. So all of this means that while schools can sometimes regulate what students say off campus, they can do so considering these three things. This one's hard. I mean, each situation is going to include a different set of facts. It'll be looked at individually, but these three factors are really important for you all to be aware of. And before we go to Q&A, I'll just give everyone a moment here. If you'd like our contact info, I also included our Twitter or X info. Robert is a lot more of an interesting follow than either Lauren or I. Lauren is associate counsel here at Will. She works on K through 12 education, legal, and policy issues. So if you can't reach me, feel free to reach Lauren. And then the link here at the bottom, schoolboardpolicies.org, that's where you can find the model policies that I discussed, or any other model policies or school board resources that we have made available. So we have plenty of time left, and with that, I think we will.
Before we go to Q&A, can I ask you a question? Because
Sure.
I'm embarrassed this has never occurred to me before because I've written some about it, but not from a legal perspective. So, as a former civics teacher, I worked in a school that encouraged student activism and passion projects, as it were. But I've noted in the last couple of years there've been any number of instances where, for all intent and purposes, there are school sanctioned protests. In other words, students may, march out in seventh period and go to the athletic field to protest, something that they're upset about. And one of two things happens. Either the administration gives its approval or does not take any action to punish kids for cutting class, which is what they would normally do if it weren't, a protest. Is there any case law there on that, or am I correct to suggest that if a school is either sanctioning or not punishing that kind of activity, they are functionally promoting it, right?
Yeah, I don't know the answer. It's a really great question. One thing though that does come to mind is in that Bong Hits for Jesus case, I think this individual, this student was actually holding this banner. It wasn't on school grounds. There was like an Olympic torch run going on, and he was across the street or something along those lines and was late to school. And in that instance, the court held, well, actually you can punish for this instance. I think the facts will have to be considered in light of all of these cases that we discussed. And as you can see, as all of the attendees can see, the court, I think, is very willing to kind of look at the different variations of First Amendment jurisprudence and application of the facts to the law. So I think this is such a lawyerly answer, but it would probably depend on some of those specific facts.
Yeah, it's one of those instances I can see school boards having to wrestle with because it is not uncommon to see student walkouts or other protests and that are either sanctioned or not punished. That's something I could easily see a lot of school boards having to wrestle with.
Mm-hmm. Well, let me see if I can adequately navigate the technology here and stop sharing my screen so that we can answer a few questions. There we go. All right, pulling up the Q&A. Robert, feel free to jump in if there's any that you see here.
Well, I'll take one here. Corey Houston writes that her school district launched a new social studies and civics combined curriculum recommendations using a vendor called Educating for American Democracy, which I'm only vaguely familiar with. The curriculum, she writes, indicates that it is nonpartisan, but it also emphasizes America's guilt and not only doesn't celebrate the founding fathers, but raises concerns about the origins of the country. What are practical ways to combat this subtle ideological influence? Again, I'm on thin ice, not being familiar with the specific lessons here, but I spend a lot of time looking at curriculum. On the one hand, I would urge school board members not to overreact to specific facets of curriculum. Something I never tire of pointing out is that the vast majority of adopted curriculum is not taught as written. In fact, I've lately disciplined myself to stop using the phrase adopted curriculum, and I now call it purchased curriculum, because that's what it is. In other words, just because a school board authorizes the purchase of a curriculum doesn't mean that it is taught, as written robotically. In fact, we know from, studies from the RAND Corporation, others, that almost literally every teacher in America customizes, curates, or creates their own curriculum, which is something school board members should be aware of in terms of curriculum transparency. It's easy to say, but it's very, very hard to do. And by the way, I should note, there are very good reasons for teachers to customize curriculum to differentiate, as it were. It's not that they're trying to subvert lessons necessarily. Um, my own suggestion to this, and I'll find this while we're before the end of the session and post a link. Some years ago, the last 2 or 3 years, I wrote a paper at AEI with a colleague encouraging the adoption of teacher codes of conduct, which used to be a big thing in many districts, and they seem to have fallen somewhat into disrepair. Which encourage viewpoint diversity, but mostly encourage teachers or teachers to honor a code of conduct that says, look, don't put your thumb on the ideological scale. You do need to present multiple viewpoints. I used to say this to my high school civics students all the time. If we get to the end of this course and you can tell me a thing about my politics, then I failed. This is not about my views. This is about your views. Um, so I would urge the questioner. I'll post a link. I'll find it, and explore the possibility of adopting teacher codes of conduct in your district.
Thank you. I see a few here that I should be able to get to rather quickly. Dates for the cases. I'm sorry, I didn't have the full citations on our slides here, but I would just recommend that you take a look at our report. Everything is cited. You'll have the full citation, you'll have the year, and you'll be able to, if you want to, look up even more about each individual case. They're all cited in that AEI CERN, which is the Conservative Education Reform Network report that we authored on this topic. I see a question about an open records request for employee correspondence regarding curriculum. Is that an open record? Yes, pending no other unexpected exception to the open records law in your state. Yes, this is something that generally would be considered an open record. And requestable, and you should be able to see what has been discussed.
I assume that means if it's in their official school or district email, not necessarily in their personal Gmail or AOL. Right?
That's a great question. Actually, here in Wisconsin, it doesn't actually matter what email is being used. If you're corresponding about official district correspondence, if you're corresponding in your official capacity, even as an individual school board member or a teacher, it still is considered to be an open records. And here at Will, we're very pro transparency. So yes, if there's discussion regarding curriculum, generally that, yes, like I said, look at your state law, make sure there's no other exception that applies or any other details. If you're here, I don't know if this questioner was in Wisconsin, but Will also has a citizen's guide to open records. Our state has a great guide as well to look at, but in general, yes, that should be
Same thing
requestable.
on your Facebook or Twitter account as well?
It could be, yeah. Usually when we request those types of correspondence, we cast a broad net to see where has this been discussed. We're requesting correspondence generally. Let's see what else. Yeah, I see there's one question here about dress codes. We do also have actually a model policy on dress codes. Perhaps not the most exciting policy to have, but I think this kind of everything always goes back to what can we do to make the classroom environment more focused? How can we enhance student achievement? And if there are less distractions while also allowing for student expression, consistent with their First Amendment rights, then that would seem to be a good policy. So yes, it should be consistent. It should respect First Amendment rights. I would encourage this individual and anyone else interested to take a look at our model policy on dress codes because, yeah, I mean, you look at the Tinker case, the displays, whether it might be political, et cetera. Students have very strong First Amendment rights. So I would encourage you to take a look at that policy and the legal analysis that goes with it.
I see a question in the chat, Corey, that I'd love to kind of add on to. Bryce Cox asks, said, we may have already covered this as I was late coming on, and we did talk about this a little bit. Where's the line with teachers displaying flags, whether religious or social stances, for example, gay pride or BLM flags? We did discuss that, but the question I had when you were discussing that was, is there a difference? Does the court recognize the difference between such displays if they are permanent classroom displays or if they are instructional displays? So in other words, there were any number of times as a teacher where I may have put up propaganda images, as it were, as an instructional matter when teaching a civics lesson, but they were not part of my permanent classroom displays. I assume that the former is okay, the latter is legally problematic.
I think you're probably right. I mean, you always go back to the facts of each situation, but yes, I would imagine that would be an instance where there could be an opportunity to distinguish. And I'll also just mention here that a lot of districts have a policy on controversial issues. So if you are going to talk about something that is a controversial issue in a way that is unbiased and for instructional purposes, many districts have a policy on how to do that. Do you have to check with your administration first? Do you have to notify parents first? Do they have a right to opt out, and exactly what that looks like? So just as a school board member, as a parent, just that's another thing to take a look at. Let's see here. Apologize for the delay, everyone. There's a lot of really good questions here, and I just want to make sure we're reading them thoroughly. Oh, on this topic of controversial displays, am I understanding correctly from the case law you presented, if a school board were to ban pride flags from being displayed in the classroom, would we then also have to ban the American flag from being displayed in the classroom? No, no. And actually in our model policy, we specifically permit the American flag, state flag, and there might be a few others along those lines. No, you don't have to ban the American flag. I'm thinking more like if you're banning something that says Biden Harris, then you can't allow Trump the viewpoint neutral, but doesn't impact our American flag. Well, one note I'll make, and I'll let Robert keep reading through these as I will as well, but a lot of these, and if you've heard me present before, you've probably heard this, but a lot of these have to do with very specific factual situations, perhaps things you're dealing with or that you've heard about going on in other communities. And I just want to encourage any of the school board members on this call, ask questions. This goes to what Robert said at the very beginning about, listen to the experts, but don't feel the need to always defer to the so-called experts, because you as a school board, maybe you don't have a background in education. Maybe your background is in something else. You are the locally elected official. you have this authority, ask questions, and you can ask questions of your legal counsel as well. If they're saying, oh, we can't do this because of case law, or oh, there's a decision that prohibits this, or our state law prohibits this, say, oh, which one? You know, what case is that? Do you think you could provide a memo, just a short memo explaining that? I know sometimes it's awkward and you feel like, oh, I should know this and I don't, but I would just encourage you all to just ask those questions and get the full amount of information before making your policies and other decisions.
There's a question in the chat, Corey, that I can't resist commenting on, but I want to manage expectations and say in advance, I don't have a good answer for this one, but it's occupied me for 20 years. And is there any case law or policy guidance on how far a teacher may veer from a school district's prescribed curriculum? This is such a complex issue for reasons that have everything less to do with the law and more to do with just the kind of the practical problems of teaching. In the last couple of years, there have been any number of states that have passed, usually in response to concerns about critical race theory, curriculum transparency laws. And I worry about them, not because I'm not in favor of curriculum transparency. I am strongly in favor of curriculum transparency, but I always caution this does not work the way you think it does. And I commented on it a moment ago saying I now say curriculum purchases, not curriculum adoptions, because curriculum almost never gets taught at the way it's written. And that's not necessarily a bad thing. We ask teachers all the time to differentiate their instruction based on student skill levels. If the standards dictate a skill and not the content, then part of the teacher's challenge is to come up with content they find will be engaging to kids. So adopted curriculum sometimes barely ranks as a suggestion, let alone a mandate. So you got to be real, excuse me, really, really careful here, because frankly, the only way to really know what's going on in any classroom is through cameras in the classroom. Would I advocate that? Probably not, for any number of reasons. But it has everything to do, I think, at the end of the day, with school culture and expectations. And it's just a really, really hard thing to mandate. But one takeaway for school board members is do not assume that just because you know what the adopted curriculum is, that you know what's happening in the classroom. You really don't.
I'll note on that too, if we have about 2 minutes left here, so if we see one we want to get to, we will in the hour that we have. I'll note though that Robert joined us here in Wisconsin last spring along with Daniel Buck, and the topic of that discussion was specifically kind of centered around what should school boards know about what's going on in the classroom. So we'll have that if it's not available already online, I'll make sure it is. So if anyone's interested in that, we have that as well. Is there one more here that maybe we want to get to?
I see a quick one. Can school boards implement a
Sure.
policy that no former teachers or school board administrators can serve on the school board? I assume that's a one-word answer, and the answer is no.
That would be my guess as well. I would want to look for the legal authority on it. But that would be my I think that's right. And before we officially wrap up here, I want to mention there are so many good questions in here. I just asked our colleague Eric to see if he can save these because there's so many great questions. Thank you all for your engagement here today. And I'll mention too that we at Will are happy to serve as a public resource for you. I do not consider myself a scholar, necessarily an expert on the First Amendment, but we have those here, our president in particular. So I would just encourage you, reach out. If we have the capacity and expertise to help out, we don't generally provide legal advice or work as general counsel for districts, but if we can point you in the right direction, point you to a case, we will. So just encourage you to reach out if there's something that comes up in the future. Robert, anything else before we wrap up here?
No, I wish we had a second hour, and maybe Corey, we should plan a second hour for this because there are a ton of good questions in the chat that I'm sorry we're not going to get a chance to, but if we want to do a second one, count me in.
All right, everyone. Yes, please reach out with your feedback. Thanks again for joining us today. Hopefully this provided a good overview for not just the school board members, but all of you on this call who are so dedicated and interested in K through 12 education, both in Wisconsin and around the country. So We wish you all a happy holidays, Merry Christmas. I'm sure we won't get anything planned before then, but thank you all, and we'll be following up soon by email.
Thanks, folks. Thanks, Corey.